Hello everyone, this is the video of Legal Studies, Class 12, Unit 2, and the topic is property law. And the topic of that property law that we are going to discuss in this video is gift. So let's check it out. What are the contents that we are going to discuss in this video? The meaning of gift, conditions of a valid gift, conditional gift, and onerous gift. So these are the terms that we are going to discuss in this video. So let's begin with the meaning of gift. As per the section 122 of Transfer of Property Act, gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration and accepted by or on behalf of the donee. So what this definition is saying, there are so many terminologies used in this definition. So let's break it and then try to understand. The first thing that's saying, the section 122 of the Transfer of Property Act. So that is understood. Next point, gift is the transfer of certain existing movable or immovable property. So here you need to focus on existing. So it must be existing, whether it is movable or immovable property, it must be existing. It's not like something futuristic object or something like that you are transferring or gifting, not at all. It has to be there in the present scene. So you need to focus on existing. The next one is saying that voluntarily. Now you need to focus on voluntarily. What is meaning of voluntarily? You are gifting your property with your full consent or with your free will. It's not something like forced. If it is forced, then it is not valid. So it has to be with free will and without consideration. And you know what is meaning of consideration? That is no money involved. So it is free of cost and accepted by or on behalf of the donee. It is also important. You are giving to someone, but he or she is accepting or not, that is also important. Whom you are giving, he or she must accept it. If she or he doesn't, then on his or her behalf, someone else must accept it. Otherwise, it is not valid. So this is the meaning of this definition, that is gift. The person who gives the gift is known as donor, and the person who receives the gift is known as donee. Now, the next point that we have, that is, what are the conditions of a valid gift? Let's check it out. What are the conditions of a valid gift? Donee must accept the gift. We have discussed that. Donee must accept the gift. Otherwise, on his or her behalf, someone else accept, or else it would be void. During the lifetime of the donor, means if you are a donee, then it's not like that you can accept at any point in time. You have to accept during the lifetime of donor. If donor dies before your acceptance, then that will be void. Secondly, while the donor is still capable of giving the property gifted. What does it mean? That though he is alive and you didn't accept that, but in the meantime he is no more capable to gift out that property. Whatever happened, if you didn't accept, maybe someone else has taken, he sold out, or whatever the things happen with that property. So in that condition, that is again void. You cannot claim that you have been gifted that property on that date because you missed the time of acceptance of that property. So these 2 points you need to focus on. Next one is, however, if donor dies before acceptance, the gift is void. We have discussed that. Now, let's check out some more point regarding the valid gift. Gift of movable property may be registered or may be effected by delivery. We have discussed above that if it is immovable property, then it has to be registered. Essentially, when its value is less than 100 rupees. But even in that condition, gift has to be registered. But if it is movable property, then it is optional. It can be executed by delivering that object or material or a stuff, or it can be also registered, or it can be also in written simply on a simple paper. So it is optional. It's depend upon the understanding of both of you. The next point is, however, gift of immovable property of any value requires registration. See, however, gift of immovable property of any value, not even less than 100, that is not essentially required. It's not like that. Essentially required registration under section 17A of the Registration Act and section 123 of Transfer of Property Act. So under these two laws, registration of a gift of immovable property is essentially required. It must be signed by the donor and must be attested by two witnesses. What is meaning of attested? Basically, eyewitness is supposed to be signing on that paper. That is attestation. The next point is, gift to God Almighty may be oral or may be in writing or may be registered. See, if you are gifting the property to some temple, church, mosque or anything of such type, in such a condition, whether it is movable or immovable property, the registration is optional. Even you can give it orally or in written form, maybe simply written on the paper, or you can also register. It is optional for this purpose. Next point is, the property must be existing at the time of the gift. We have also discussed this point, that when you are gifting out the property, then that has to be there in the present. It's not like something that you imagining or you planning to buy and then gift, that will be void. So the property that you have, that is in your possession and you are the sole authority of that property, only then you can gift it out. The next point is, as per the section 124 of the Transfer of Property Act, a gift of future property is void. We have discussed this point, that if you are planning to buy certain thing, suppose a car, and then gift it out, then that is void. That cannot be claimed. But the property that you have already and you are gifting that is valid. So you cannot gift out something that you are going to have in future. The last point of a valid gift is, as per the section 125 of the Transfer of Property Act, when a gift is made to several persons, please pay attention, when a gift is made to several persons and one or more donees doesn't accept, then it is void respect of those who do not accept. Let's understand it with an example, that you have basically a piece of land, say 5 acres of land, and you are gifting out that to 5 people. Out of those 5, 2 people do not accept that gift. Then what will happen? The 3 person will take 1 acre each, as divided as 1 acre each, and the 2 acres of those 2 persons will be void and that will remain with you only. So this is the meaning of this section 125. So the whole gift won't be void, rather it will be void regarding those who didn't accept that. Now the next topic is, when can gift suspended or revoked? Is there any possibility to revoke or suspend the gift? Another way to ask this question. So let's check it out. The fundamental rule is that a resumable gift is not a gift at all. Please pay attention. A resumable gift is not a gift at all. Resumable means once you gave someone something on the terms and conditions that he or she needs to return back, that is not a gift. Please keep in mind. So if you are giving it finally for rest of the life, permanently, only then it is a gift. So resumable gift is not a gift. Next point is, a gift once given cannot be revoked at the mere will of the donor. such a gift is made is void ab initio. So gift is gift. You cannot make something like that, you gift it and then you want it returned back, whether it is written or not, whether it is registered or not, depending upon the nature of the gift that you have given. If it is orally executable, then even in that condition you cannot take it back by saying this, that you don't have the proof that I have gave you this. So gift once gave, that is permanently gave, and if any terms and conditions put on the gift, that is void ab initio, means from the beginning itself. The next point is, though a conditional gift is void, but a conditional gift which attaches a condition subsequent is valid if the condition is not vague or illegal or immoral or opposed to public policy or impossible of performance. Hence, conditional gifts may be made. So, what this provision is saying, basically defined under section 126 of Transfer of Property Act, that is saying that in certain conditions conditional gift is allowed, but those conditions shouldn't be vague, illegal, immoral, opposed to public policy or impossible of performance. And I believe you must understand all these points because we have discussed all these points, that is illegal, immoral, opposed, public policy or impossible of performance, everything we have discussed. Nevertheless, one point more that is not discussed in our previous video, that is vague. Vague means something that not clear. Whatever the terms and conditions you giving, it is not clear what you are basically looking for. So it has to be clear what exact terms and conditions you are putting. So in that condition, gift may be valid. The next point is, gift made under coercion, fraud, undue influence or misrepresentation may be revoked by the donor. What does it mean? That if someone forced to gift his some property or cheated by some other means, by telling lies, in such a condition, donor can revoke the gift. As we have discussed above, that gift has to be with free will. So in such condition, it is not with free will, so it can be revoked. Now the last topic of this video is, that is, what is meaning of onerous gift. As per section 127 of Transfer of Property Act, a single transfer made to the donee, but some of the properties gifted are burdened by obligations. The donee must take the entire gift. If he accepts only to take those which are without obligations, then the gift is void. This is not something new. We have discussed this point earlier as well. Remember, regarding the sale, we have discussed that in one transaction you cannot accept something or reject something. Either you accept or reject. Remember something? That is, if some property you are offered and that has the liability. For example, you are offered a flat, but there are some liabilities attached with that flat. Maybe there are certain loan over that flat. For example, that is the worth of 2 crores, that flat, and there is liability of say 50 lakhs. So it is still beneficial deal. So in that condition, if you are accepting that flat, then you have to also accept the liability of that 50 lakhs. However, if the gift is 2 or more separate and distinct transactions, then donee may select at his liberty and refuse those which are not beneficial to him. It means simply this, that if they are separate properties, something may be without liability and something with liability, then the donee has the freedom or liberty to select or to reject. So This is all for this video regarding the gift. We have discussed so many points regarding the meaning, the condition of valid gift, when can it be suspended, and of course the onerous gift. So I believe you must understood all these points. If not, then again watch it again and again. So see you in next video.